Shall we invite the administration in, please?
今日出席我哋會議嘅呢，就一路都係呢排都成日見啦，就係食物及衛生局。
With us for this meeting, Permanent Secretary of FHB, Mrs. Marian Lai, Mr. Philip Chen, Mr. Thomas Lin from the Customs and Excise Department, Mr. Howard Yam, Assistant Director General Trade and Industry, Mr. Gilbert Mo, Deputy Law Draftsman at DOJ, Mr. Peter Z, Senior Government Counsel at DOJ, and Dr. Alan Chan, Senior Medical Officer, Risk Assessment CFS. We're done with the clause-by-clause scrutiny of the regulation. There are still outstanding questions for the administration to respond to. Our legal advisor has got questions that remain unanswered. There is a reply kindly given to us by the administration. Mrs. Lai, over to you, please. Well, at the last meeting, members expressed some reservations about the phrase any other relevant circumstances, and they have called upon us to conduct some research about other legislation that contains this particular phrase. And they've also asked us whether, in absence of this phrase, the definition will stand effectively. And after conducting the research, we are of the view that there is a need for this phrase, otherwise there would be loopholes that would arise. That if we simply rely on the product descriptions and users' instructions, and if the descriptions or instructions have been tampered with or covered up, there would be no other means for the law enforcement agencies to make a distinction as to whether the product falls within the ambit of the regulation. If people were to carry the powdered formula in other containers without any product descriptions and instructions, it would be very difficult for the enforcement agencies to enforce the law. So there will be concerns if this phrase were to be done away with. So we insist that this phrase be kept on in the definition. As regards other pieces of legislation, perhaps I defer to the Deputy Law Draftsman, Mr. Gilbert Mo. Chairman, in the annex to the paper, we have identified several examples in the legislation of Hong Kong. Regarding the legal liabilities and so on, there is such a phrase, any other relevant circumstances, and so on. Because if we rely on the specific circumstances included in the legislation, we may not be able to cover all the myriad circumstances that should be included. So we would adopt the drafting mode that would include the phrase any other relevant circumstances to plug the gap and to cover the kind of situations that are not specifically mentioned in the legislation. In the annex, we have a couple of different categories. Some have to do with the criminal liability, some have to do with the legal rights and liabilities, and so on. Now, in this regulation, we have included this phrase in the definition because the definition of powdered formula appears in the schedule as well as the principal regulation. If we have this way of drafting, then it has to do with the legal rights and liabilities, and it doesn't have any difference from other pieces of legislation in the form of drafting. As Permanent Secretary said a moment ago, there is a need for this to appear, and it is a common practice in drafting legislation. All right, then. I now throw the floor open for questions. 5 minutes each, please. Questions, please. Mr. Kwok, Chairman. Well, we talked about the definition last time, and I did ask the government officials that for a powdered formula, if we're not sure whether it falls within the definition here, and someone carries this product across the border, and he's stopped, and then the Bureau approached the suppliers for information relating to the product, and the information so derived will be used to determine whether the product falls within the definition of the powdered formula, and it is likely that this person may be held liable. And is this still the attitude of the Bureau? Chairman. Well, under these circumstances, if we have to seek information from the supplier, then we will seek information relating to what is required by the law, and that is whether the product is intended for or claimed to be for consumption by persons of any age under 36 months in the form of powdered formula or soy milk powder for nutritional requirement. Mr. Kwok. But that I'm aware. Thank you very much for your explanation. We're dealing with powdered formula, not drugs. Powdered formula doesn't cause any harm at all. It is readily available, and they come in so many different brands. If someone wishes to ascertain whether a powdered formula falls within the ambit of the regulation, we have to make it very clear, because we don't really want anybody to be held criminally liable unawares. So the phrase any other relevant circumstances would give rise to concerns about the law enforcement situation on the front line. Now, we have been debating this for some time here. All the problems arising from this definition have been highlighted by members. Now, if we are looking at this piece of legislation and decide whether we can carry a certain product of powdered formula, it is still very confusing. Now, we were told by the draftsman that the inclusion of any other relevant circumstances is because they are concerned about the parallel traders tearing off the label or transferring the powder formula elsewhere into other containers. This can be dealt with under the law. You don't have to resort to this ambiguous phrase, any other relevant circumstances, to cover the circumstances that you alluded to. Mrs. Lai. Thanks very much, Mr. Kwok. we have to stress that parallel trading is evolving pretty rapidly. When drafting the law, we can visualize these kind of trading practices, but we cannot rule out the possibility that in the light of this provision, they will come with alternative means to circumvent the regulation. Mr. Kwok, now let's say someone were to pour all the powdered formula into a box, and he's caught crossing the border, and you still have to refer this formula to the government laboratory for testing. Now, let's say you identified the brand, and then you ascertain whether the brand falls within the ambit of regulation. Is it how you go about it, Mrs. Lai? Well, when enforcing the law, we will ascertain the kind of product with the relevant people. Mr. Kwok, well, I think you can make it very clear in the regulation without having to use the phrase any other relevant circumstances, because at the end of the day, you would have to have regard to the labels. To ascertain whether it is meant for babies, you don't really have to seek information that the member of the public is unaware of in order to make the identification. Mr. Kwok, I think your point has been well made, but the administration insists on their own position. My advice for you is that if you disagree with the way the definition is couched, you may wish to move your own CSAs. Dr. Lo Wai Kwok. Chairman, I don't think I have heard any solution or any improvement to the point that I made about the 24-hour requirement. The Customs and Excise told us last time that a third of those prosecuted flouted the 24-hour rule. There are visitors who may be taking the powder formula on an irregular basis. I mean, he probably may not remember that yesterday and today he cannot bring the powdered formula because he falls within the 24-hour rule. Now, the idea of the ban is to stop people bringing the powdered formula within a day. I think that you can do so without imposing the 24-hour rule here. I used to travel back and forth between Hong Kong and the mainland. It would be very difficult to remember exactly when I crossed the border yesterday and whether I am still within the 24-hour period. So from the prosecution figures, how many of them have been caught innocently? My concerns may not be unfounded if you look at the figures. Mrs. Lai, I answer the question first before I hand you over to Mr. Lin. Well, as I said last time, any regulation that we impose will cause inconvenience to the stakeholders. But we have to ascertain whether the regulation is in proportion to the policy intent and whether it is reasonable.
This requirement on the first-time departure within 24 hours is to strike a balance for the ordinary members of the public. They may have a need to bring along powdered formula with a child. They can bring 1.8 kg. But for the parallel traders, they hope very much to go back and forth frequently with their parallel goods of powdered formula. So if we relax the 24-hour restriction, say it's not the first time when they depart within 24 hours, then that will bring down the costs for the parallel traders. I don't want to hear these repeated sort of answers. My question is, how can you draft it in a way that people can travel one or more times within 24 hours? Can you do it or not? Just give me a simple reply. Don't repeat the answers. Yes, I defer to Mr. Lin to take us through the law enforcement angle. Mr. Lin, thank you, Chairman. This 24-hour period restriction from the law enforcement point of view, we think is necessary because in past examples, we do see that there are different syndicates, large or small. Their operation is that they would accumulate a certain powdered formula in Changshui and other north areas in North District, and then the parallel traders would travel back and forth many times within 24 hours. Well, we are well aware of that. I've got only 1 minute left. Please answer my question directly. I'm aware of what you said. So my question again is, can we put or impose a restriction and then relax the 24-hour period? Well, I don't know how you are going to do that. If you can't do it, just tell me you can't do it. Yes, I think Mr. Low wants a simple reply from you, yes or no. Chairman, if we talk about once every 24 hours, we must have this 24-hour restriction. We said that in the draft, we said that it's the first time in the 24-hour. So I think that can achieve the policy objective. Now, I said that if I depart at 10 a.m. yesterday, and then I depart at 8 a.m. today, then I am in breach of the law. Is that right? Yes. Her answer is very clear. No. Straight note. Yes, Mr. Christopher Cho, I want to follow up on Mr. Low's question. When you enforce a law, would you have a discretionary power? Say at 10 a.m. yesterday, I brought along 2 or 3 cans of powdered formula, and then I depart at 8 a.m. today, and I bring with me a child. Can I bring another 2 to 3 cans of proposed formula? Are you asking me to leave behind these 2 or 3 cans? What are you going to do as far as law enforcement is concerned? Mrs. Lai, I'll defer to Mr. Lin. Thank you, Chairman. Within the stipulations, there are 2 kinds of exemptions. One is that if the person leaves for the first time within the last 24 hours, he is allowed to carry powdered formula not exceeding 1.8 kg in weight. And then the second exemption is that if the person is living together with a person aged under 36 months, he can carry a reasonable quantity of the powdered formula and depart from Hong Kong. And these stipulations have taken care of people who go out of Hong Kong for more than one time within the 24 hours, and they can take whatever is needed. I want to clarify the definition. Is powdered formula, this term, powdered formula, is a very generic term, a general term, is commonly used, and is being used. The name is being used in a lot of such commodities. Now, if the product carries the name powdered formula without an age bracket contained, and it applies or can be consumed by all kinds of people, and actually a lot of powdered formula can be consumed by people of all ages, those above 12 months of age. Now, if that is the case, then if you see the word powdered formula on the product, then arrests will be made. Would confusion be caused by such a definition? How are you going to tackle the problem? Mrs. Lai. if the label says clearly that it can be consumed by people aged 12 months or no, but that doesn't mean that arrests will be instantly made. Now, Mrs. Lai, I'm saying that the label doesn't carry any wordings at all as far as the age bracket is concerned. Now, as I said last time, if no age bracket is contained in the labeling, it won't fall into the ambit of the regulation. So you are actually allowing people to circumvent the regulation. They will just do away with the description of the age bracket. I think you should consider this point. So what are you going to do? Mrs. Lai. Chairman, we have thought about this point seriously. The powdered formula sought after by the parallel traders is really for people or young children aged 36 months or below. So if the powdered formula can be consumed by persons aged 12 months or above, they may not be the focus of the parallel traders. So if the powdered formula applies to such a wide age bracket, and it doesn't fall into the definition, then there will not be any problem. Okay, Chairman, that doesn't address the problem. Say, my product is the same as that for people aged 0 to 36. It's just that I don't put that on the label, then I can circumvent the law. Yes, Mr. Chung, I think you have made your point clear. I think out on the market there isn't such type of powdered formula. That might be a business opportunity. If there is a great demand in the market, maybe you can think about engaging in that trade. Yes, Mr. Alan Leung. Thank you, Chairman. First of all, Mr. Lo Wai Kok. What he mentioned is really a problem indeed. Mrs. Lai said that a person is allowed to carry 2 cans of milk per day. Can we just say within the same day instead of in the last 24 hours? Because Mr. Low mentioned about a person departing, say at 10 a.m. yesterday and 8 a.m. today. But then I think that shouldn't be a problem if that is the scenario. So I just want to hear further elaboration on why we can't draft it in a way, say it's within the same day rather than within 24-hour period. Now, on the paper tabled today, Mr. Mo will also agree that as far as other relevant circumstances, these circumstances should be avoided as much as possible when it comes to considering it from the perspective of the rule of law. Now, it depends on how the enforcement officer will view it when it comes to this phrase. Now, when you look at Annex 2 of the paper, you have a rough idea what other relevant circumstances refer to commonly. They are referred to circumstances within a specified area. Now, when you look back at the present case, powdered formula, in our proposed new definition, you have added this phrase, any other relevant circumstances. But this is not directly comparable to those listed in Annex 2. I think it's a matter of degree. Do you have a sort of model phrase, or how far can you depart from that model phrase? What kind of circumstances would you foresee in the present case? Now, if you look at how it is written, powdered formula means any substance in powder form, that having regard to any product descriptions, now product description is one thing, and user instructions is another thing. Now, from product descriptions and users' instructions, we can understand whether it is a powdered formula, and that should also suffice, I think. And you also mentioned any other relevant circumstances. So what are these other relevant circumstances which can be comparable to the product descriptions and users' instructions? And how would you make it clear to the general members of the citizen? So, because the penalty for breaching the law is imprisonment, and it's very serious, and it's we are very worried. And it is now, as legislators, if we don't take the perspective of the members of the public who might be affected by the new regulation, and if we allow the law enforcement officers to have a say on how the law should be enforced, then that departs from the spirit of the rule of law. And under the rule of law, we should be objective and accurate. So, Permanent Secretary, Mr. Mo, can you address the 2 points of concern I raised? Mrs. Lai, please. Thank you, Mr. Leung. About the 24-hour period restriction. Now, if a traveler forgets when he departs from Hong Kong last time, and actually, well, there is nothing much we can do about it, even if we are going to revise the wordings. Now, if we are to revise the wordings to within 24 hours within the same day, that means from midnight to the midnight the next day. If we go along that route, that will bring convenience to the parallel traders. Say, if he can, well, actually, he can bring double the amount within a few minutes if we go down that route at the 24-hour clearance points. Say, he can bring 2 cans at around 11 p.m. and then after 12 midnight, he can bring another 2 cans. And so that would make it more convenient for him. So we have questions on whether this is the most appropriate way of doing it to achieve our policy objectives. We do have reservations on that. Now, as for any other relevant circumstances, are they consistent with the phrase product descriptions and use instructions? I'll defer to Mr. Mo. Mr. Mo? Mr. Leung asked about what other circumstances there are. Now, for product descriptions and uses instructions, there are no further elaborations on these 2 phrases. So a scenario may appear as what the Permanent Secretary said, that people may add in the product descriptions and uses instructions later on. So the original product descriptions and uses instructions may fall into the category of definition of any other relevant circumstances, and we have to find out the original production status. If we have strong evidence, witnesses or otherwise, pointing out that say the label of the product has been tampered with, but then in effect, originally the product with that description should fall under the ambit of the amended regulations. So that would fall into the category or the definition of any other relevant circumstances. So if we do away with that phrase, then the effect of the regulations will be very different.
Well, we are dealing with certain products consistently. The Customs and Excise Department will have guidelines to minimize any difference in the law enforcement exercise. Mrs. Lai. Any other relevant circumstances, members may question whether this is strict enough. Now, in fact, this has to be read together with the other phrase, intended for or claimed to be for persons of any age under 36 months. So this is really interlinked with the rest of the definition. Mr. Lin? Well, the law draftsman mentioned the law enforcement. If I may add a little bit here. At the border crossings, normally the powdered formula would clearly specify the content. Now, here in this regulation, assuming that we have some extraordinary situation where someone has removed the labels on the tin, and in extreme situation like this, where someone brings the powdered formula in containers that do not show all these specifications, then we would take the position that we haven't established any reasonable doubts, and we would not take any particular action, but for syndicated kind of activities, the Customs and Excise may conduct a further investigation. The members are concerned that the members of the public may bring one or two tins across the boundary, and from the container it would be difficult to ascertain whether it is the kind of powdered formula that falls within the legislation. Then we cannot establish any reasonable doubt, and we will not take any enforcement action. Mr. Paul Che. Chairman, if I may raise this question first. A friend of mine has to make the crossing to Shenzhen every single night, and every day he comes back to Hong Kong. It is less than 24 hours. Well, if he doesn't have any residential address in Hong Kong, does he have to stay somewhere before he would be able to bring any powdered formula? Or does he have to make the crossing deliberately before he would be allowed to buy any powdered formula? It is very inconvenient for him. In answer to Mr. Leung, you said that 24-hour is the cycle that you have in mind. Now, the parallel traders may make the crossing at midnight or midday. I mean, do we have to be so strict about the 24-hour restriction? Now, Mr. Gilbert has given us all these examples in Annex 2. I've gone over them in sufficient detail. I'm grateful to Mr. Mo for the effort within such a short period of time. Now, a lot of the examples here the prosecution doesn't have to be concerned about all the elements being in existence, and the defense has to argue for the case, and it is in a rebuttal, maybe something has to be done. It is for the prosecution to prove this particular case. and also all other relevant circumstances. Now, what is a reasonable defense and what is practicable? It is only in particular circumstances that we use these any other relevant circumstances. And this may not be of good enough reference value for us. So how would the administration respond to this? I think the nearest example is number 9 regarding the specimen. Now here it is rather unique. They have cited all these examples that they would include this specimen, but the scope is more narrow than this. Here in this regulation, the scope is much broader. So before considering adopting any other relevant circumstances, will the administration consider that there is clear evidence that the labels have been tampered with, that this would be resorted to make sure that the scope would not be unnecessarily broad. Mrs. Lai. Chairman, in order to combat parallel trading, this 24-hour restriction is necessary. At the enforcement level, the Customs and Excise has noticed that some syndicates would employ some casual workers who are making frequent trips in quantities that may be more than 2 tins on some occasions. So this 24-hour restriction will aggravate the situation if it is relaxed. Mr. Lin. Chairman, thank you. I'm sure members have noticed that over the past couple of days, the Customs and Excise has taken a whole series of measures to tackle the syndicates that arrange for parallel traders to carry the powdered formula across the boundary in frequent trips. And this 24-hour restriction is effective in combating this practice. In some cases, they make a couple of trips within a single day. If the definition is relaxed, then we are making it very easy for the parallel traders. Now, this definition here, as it is, would be more effective in combating parallel trading activities. Mr. Chung Kok-pan. Chairman, in this new definition of powdered formula, it mentions that if someone were to tamper with deliberately, or if someone were to change the labeling of the powdered formula, there may be problems, and they are concerned about this happening. I remember when we had this meeting, the subcommittee meeting, I put a question to Dr. Ko Wing-man, and in reply, Dr. Ko said that the buyers, the mainland buyers, like these products because they contain the Hong Kong labels. And any labels that have been tampered with would not be as favored by the mainland buyers. I think this definition runs counter to what Dr. Ko said. Now, Dr. Ko said the tin would make a difference, and now you said you're concerned about the tin being tampered with. Mrs. Lai. Well, I don't see any contradiction between the two. Dr. Ko, what Dr. Ko said is absolutely right. The parallel trading activities are so rampant because there is a price for the powdered formula with high reputation, and they are sold without without being tampered with. But the parallel trading activities are ever evolving. We cannot rule out the possibility that someone may be bringing the powdered formula across the boundary using other containers. And such practice would also take a lot of products away from the supply chain. So we have to have regard to this kind of scenario. There may be individual circumstances in which they will split up the products at the departure hall. Now, if the legislation is merely concerned about the original tins, there may be loopholes. Mr. Zhong, if Dr. Ko is right, which I think he is, the mainland consumers feel that Hong Kong products are more secure, but if they transfer the content into a plastic bag and bring it across the boundary, would the mainland buyers have any faith in it? I do have doubt myself as a consumer. Mrs. Lai? Chairman, what Mr. Zhong said is realistic, but I think the legislation has to be sufficiently comprehensive and must be applicable to all these situations. Mr. Zhong, well, I appreciate that it has to be comprehensive, it has to be proper, but I mean, we're dealing with all kinds of powdered formula, those for the pregnant women and those for the elderly people, and even Holic, as mentioned by Mr. Dennis Kwok. And this is too broad in scope. We're not really talking about powdered formula for babies under 36 months. But if they transfer the content into other containers, it would be very difficult to make any distinction between the powder formula and Holic, for instance. Mrs. Lai. Well, I mentioned other containers that are used, and the other possibility is that someone may be tampering with the labeling, or they may change the labeling on the tin. And in some other cases, the purchasers and the sellers may establish certain business ties, and they can sell the products despite the tins being tampered with. And this would take a lot of the products away from the supply chain. We do need this phrase in the definition to make sure that the law enforcement is smooth and effective.
Next, Mr. Sin Chung, I have a couple of points following up on Mr. Lo Wai Kwok's points and Mr. Paul Chair. Mr. Lo is concerned about the 24-hour restriction. Is it possible that you deployed ID card reader for people to check whether they have left Hong Kong within the 24 hours? That can be done with Octopus card reader. So those who commit mistakes inadvertently will be given a chance. Now, on Mr. Paul Chair's question, what I'm going to talk about may be very rare, but I need to go to work on the mainland within 24 hours. In the first time when I travel to the mainland, I might not need to bring powdered formula, but on the second time, and I might need to bring powdered formula, maybe you can issue a certificate certifying the person has not brought any powdered formula in the first time when he leaves Hong Kong. So that can serve the purpose. And then the certificate can carry his ID card number and name and so on and so forth. So I think that can address the problems where people have a real need for bringing powdered formula across the border. Can you think more about these administrative measures to resolve the problems? Because no one from Immigration Department is here today. But then can you think about deploying ID card readers? I don't think it will be that difficult because you have all the records with you in the computer. I've heard Mr. Sin's views. I can't guarantee that I can follow up because it involves other disciplines or other professional practices for other government departments. Is Customs and Excise Department, you have a representative here? Yes, right. So can you issue certificates to certify that the person has not brought any powdered formula the first time he leaves Hong Kong? Can you do that? Thank you, Chairman. Actually, the question has been discussed in past meetings, whether we can institute a declaration system declaring that I didn't bring any or carry any powdered formula last time. But when we look at the very border crossings with very heavy traffic, say Lowell, ZPB, thousands of people leave every day. If there is this measure suggested by Mr. Sin, that measure has to be applicable to all people in an equity manner. And if we have to deal with so heavy traffic in terms of people flow, then we do encounter operational difficulties. We envisage we will encounter operational difficulties. So you're not willing to do it, is that right? Yes, that's very clear from his answer. The next one. Before the next member asks a question, the legal advisor has certain opinions. I have heard members' views. Can we change the wordings in Roman letter 1? It says here, the person did not leave Hong Kong in the last 24 hours. Say, I don't know what members feel about this. Say, if we do away with that clause, because it is very difficult to measure sometimes, if we say the person did not leave Hong Kong on that day, we actually, in fact, we are talking about 24 hours. But then if we say that day, then the person will know whether he is leaving once or twice on that day. So is this what members wanted? Administration, do you have any response to the legal advisor's suggestion? It's Mrs. Lai, please. As I said, actually we've thought about that. Say midnight today up to 12 midnight the next day. That's a calendar day. Our reservation is this. Then it will bring convenience to the parallel traders, especially for border crossings which operate around the clock. The parallel trader can actually bring double the quantity of allowable powdered formula within, say, 10 or 20 minutes. We don't want to relax that because at the moment people are already circumventing this requirement, and actually they are traveling more than once within the 24-hour period. And if we further relax that requirement, then we would erode the authority of the enforcement officers in enforcing the legislation. And that would also bring a very confused message to the community as far as the requirement of the law is concerned. Legal advisor, do you want to follow up? Actually, this loophole appear all this respectively, and with the existing wordings. That would also happen with the existing wordings. You can't avoid that situation. The problem exists with the present wordings. Or there is always a gap in the theory and the real between the law and the real situation. And I think the administration can think more on whether you can achieve your policy objective while making the wordings clearer at the same time. Next one, Mr. Gary Fan. I support the restriction order. From September 2012 up to the 30th of April this year, a total of 679 people were arrested. Of them, 10 are mainlanders. There are some 10 to 20 people, a dozen people on various days on parallel traders. As of yesterday alone, 4,000 kg of powdered formula were seized yesterday. The administration, do you think the situation has improved? I think the problem has persisted. It's just that the form of parallel trading has changed, and that is why we have the situation where people were enticed by, say, $20 to $30 to engage in parallel trading. And in newspaper reports today, the parallel traders' active points actually have shifted to Lok Ma Chau, and the parallel traders are outwitting the administration, say in the Netherlands and in other places. There are other forms of milk restriction orders, say in the UK last month, March 2013, the scrupulous merchants imposed the restriction that only 6 cans of milk powder can be purchased, but now they are changing it to only 3 cans or only, because the illegal or the parallel trading activities were so rampant. And for the producers, like New Zealand, there is also panic buying of milk powder. So the administration, have you thought about this? Now, if the parallel trading activities persist and they are still rampant, and would you changing or further restricting it to 1 can only, or introducing a departure tax or levy on the powdered formula being taken out of Hong Kong? I think you can't use a piecemeal approach, because there are so many travelers coming from the mainland over to Hong Kong, and they are scrambling for milk powder in Hong Kong. I think we should do away with the multiple entry permits as well. Mrs. Lai, Chairman, actually the parallel trading activities are rampant, and there are also smuggling activities. So this C and ED colleague can supplement. We do need the amended regulations to combat parallel trading activities. Now, for this restriction on 24-hour period, would you give people the impression that they can bring 2 tins of milk powder after the 24-hour period? Because we are very categorical in that the person is allowed to take 2 cans within the first departure of a 24-hour period. Mr. Lin? from the number of cases, there are a dozen breaches at the customs on a daily basis, and this has continued for a number of periods. In the past couple of days, the customs had launched or mounted several different operations, and actually the parallel trading syndicates will, based on the market situation and the demand and our surveillance efforts, adjust their strategies. So in the several cases we encountered, the operations were of a smaller scale, and several people accumulated a quantity of powdered formula and asked people to carry it over across the border. And there are syndicators which were larger in scale. They piled up several thousand tins in a warehouse, and they organized systematically a large number of people carrying powdered formula across the border. When we first launched the restriction order, we thought that things were rather in order. But then our recent intelligence tells us that the parallel traders are now storing the parallel goods in different car parks or mobile warehouses in different parts of Hong Kong. So overall, the parallel trading activities are still very rampant. Next, Ms. Sit Ho. Thank you, Chairman. I must apologize first that I have not joined this subcommittee, although I was the one who suggested at the House Committee that the subcommittee be established, because I had to go on a business trip, and I was afraid that the subcommittee would already ended its work when I came back. But I would like to thank members for being so careful in scrutinizing the amendment regulation. Now, I would like to share my views. First, I think we should safeguard the supply of powdered formula for local babies. Earlier on, the government set up a hotline to help mothers to buy milk powder. Some people may criticize the government for using public funds to help mothers, but I don't agree with that. I think the issue has to do with the supply chain. And during the peak sales periods, the supply chain may not be able to provide an adequate supply for local mothers. First, we would have to ensure that there is adequate supply for local mothers. Second, a milk restriction order is necessary. If we travel to Europe, we see that the visitors will, say, stock 2 tins of milk powder. And also, thirdly, we can impose a tax on the powdered formula if it is going to be exported. Now, so many questions are still pending when it comes to the amendment regulation. I don't think it's satisfactory. Dr. Ko also admitted that there are problems in law enforcement, and then there are problems also with the amendment regulation. But then Dr. Ko remains non-committal on when the review of the regulation will be conducted. I would suggest that a sunset clause be included. I have consulted some colleagues, 6 months, 9 months, or 1 year. I would propose 1 year. That if we include 1 year, then that would cover the next Lunar New Year. Then we will be able to see how the situation goes when we come to the National Day celebration and the Golden Week on 1st of May and so on. And we must have this sunset clause. And we must conduct a review. And if we find that the situation is still not satisfactory, then we can continue with the implementing the amendment regulation. What is most worrying is that the government, without such a sunset clause, refuses to conduct a review, even if there are problems.
So I'd like to put forward this idea. Once again, I regret that I couldn't attend this subcommittee earlier on. This is a very simple and straightforward idea. I hope the members would comment on this. Ms. Sit-ho, at earlier meetings, we did have sufficient discussion on the idea of the sunset clause. Perhaps I can call upon Mrs. Lai to respond. Ms. Ho? Well, I left it so late to speak because other than logging on to listen back to the meetings and listen back to the concerns raised by members of different political persuasions. Now, this definition is something that is unresolved. We're still poles apart on the 24-hour restriction. Well, we're pressed for time. As you said, you've listened to members' views on the web. Mr. Lai, you care to respond to Ms. Ho's idea? Chairman, sunset clause, the government does have reservations because we feel that the sunset clause would convey a message to the community and the parallel traders that there is a time frame on this, and it is likely to see a repeat of the situation that we saw during the Lunar New Year. And this, if members are concerned that without a sunset clause, the government doesn't review the situation, I don't think members should be worried about it because we have given the undertaking that we will review the implementation of the regulations. And we have already started a whole series of meetings with the retailers and suppliers about the order arrangement and how the stock can be replenished and so on. At critical time like the golden holiday period, the Lunar New Year period, we have to find out whether the supply chain would stand the test of the stand up to the pressure. So the idea of a sunset clause is undesirable as far as we are concerned. Ms. Ho? Well, Chairman, that's why I'd like to have a one-year period which will cover the next Lunar New Year. And I don't think the sunset clause would convey the message to the parallel traders that there is a time limit on the regulations, because a few months prior to the end of the sunset clause, the regulation can be extended. Ms. Sit-ho, I'm sure your message has got across to the administration. Before, there were members who made similar suggestions or similar views. The administration position has always been consistently the same. If you insist on this idea of a sunset clause, now you may not be a member of the subcommittee, you still have the obligation, you still have the right to move a CSA at the LegCo meeting. Mr. Paul Chair. Chairman, before I carry on with my question a moment ago, I'd like to clarify that Mr. Gary Fan mentioned other jurisdictions that impose restriction orders. According to administration, this is a really voluntary commercial initiative, and this is not really a restriction order imposed by the administration. I'd like the administration to clarify this. I don't really want to have any misconception. I think I'd like to clarify whether this is an official restriction order. Now, coming back to my question, Mr. Gilbert Moore gave us all these examples about the proper understanding of the legislation, what is practically reasonable, and And number 6, also reasonable. Number 8, any other relevant circumstances. And number 10, also reference to all relevant circumstances. Number 8 doesn't mention the reasonableness, but in the footnote, in the asterisk, it mentioned applicable. And number 11, the nature and the standard and so on. Now, all these definitions give you something for reference. Now, in number 2, for instance, nothing in the section renders unlawful any act done by the employer. Number 4, also a defense. Number 3 also gives a defense. Number 6, no action will lie in respect of trespass. Number 8, also an exemption. Number 11, it is also an exclusion provision. Now, you have this mode, which is either an exemption, or a defense, or there are certain conditions that would be taken into account. Hardly ever do you have a definition like the powdered formula, in which you have such a broad scope that is adopted. It would be difficult for the law enforcers to really have any clear idea. Now, Mr. Mo, why do you have to have such a broad scope? You're not qualifying all the reasonable circumstances. You're not dealing with all the exemptions. Rather, you have this very broad scope in the definition. Mr. Mo. Chairman, I agree with Mr. Paul J. up to a point. I have analyzed all the nature of all the different legislative provisions. In fact, there are situations where the prosecution has to establish things like the signboards of the vice establishments, and all these establishments must be construed to be advertising for these premises, and one has to consider all the different circumstances in 1 to 4, and the prosecution has to establish all of these. Mr. J. Well, within the bounds of reasonableness, you have to establish all these conditions. Rather, here in the definition, you have such a broad scope. Mr. Mo. I hope the members would understand what is relevant what are the relevant circumstances. It would be difficult to be exhaustive in the definition. In this new definition, if we do not add the phrase any other relevant circumstances, then the consequence is we have to rely on the product descriptions and the user's instructions as the yardstick to determine whether the product is intended for the relevant people. And we have talked about the difficulties in law enforcement if the definition is couched in those terms. Now, we are faced with a situation where if we do not add the phrase any other relevant circumstances, the regulation would be hard to be enforced. And this is something that we're not keen on. But when couching the definition would be rather difficult to avoid because of the practical need. And it may vary from legislation to legislation, but if you refer to the examples, can we remove any other relevant circumstances in those examples? Now, you find that if we take away the phrase any other relevant circumstances in these examples, the same problems will occur. And we cannot avoid the same thing in these other examples. there will be problems with regard to implementation. Mr. Che, now are you responding to the situation that I highlighted? You merely mentioned the difficulties in enforcement. Now, with regard to this restriction order, can the Permanent Secretary respond to this, please? Chairman, we at the non-government level, there are such orders. The TIDD gives some information before, perhaps, and Mr. Yam, I wish to supplement. Chairman, thank you very much, Mr. Che. For the question about other jurisdictions, we have looked at the WTO notices. Now, for wheat, maize, barley, wheat, flour, there are temporary restriction orders or export quota or export license that have been imposed. Are they Eastern European countries? Well, Bulgaria, Czech Republic, Hungary, Macedonia, Poland, and Ukraine we have found examples in these various countries. Ms. Chung Kwok-pan, Chairman, the Permanent Secretary said that they are liaising with the suppliers and the retailers about the supply chain. My question for the administration, how far along is your liaison and what is the latest progress? Mrs. Lai. Chairman, thank you. Thanks very much, Mr. Zhong. We have met the stakeholders on a preliminary basis to find out about the supply chain and at the retail level whether there is an arrangement for placing orders. There are so many stakeholders involved at the retail level, and if they do have this arrangement, we have to ascertain whether they would be able to cope with massive orders and whether the procedures are smooth, and they may need to have some stress tests during the peak period. Mr. Zhong, massive orders, have the suppliers given any undertaking that they would be well stocked to cope with massive orders? Mrs. Lai. The suppliers told us many times that they are confident that they would have enough supplies to meet the demand of local babies. But with regard to demand outside Hong Kong, they cannot be quantifiable. They are not all that certain. Mr. Zhong, I find this rather inconsistent. Last time we were told that the stock is 8 times or 10 times that of the demand. Presumably that would be sufficient for local babies. And there is a surplus of about 30 million kgs. As for sure, there would be sufficient supply for Hong Kong. The suppliers told us at the public hearing that there would be sufficient supply. And this is really a far cry from what is mentioned by the Permanent Secretary. Permanent Secretary? Chairman, thank you. Now, the suppliers said that there would be enough supplies to meet the demand of local babies. It doesn't mean to say that the products can be made available to the purchasers. Now, we have to put the supply chain back on the right track, like we need to have a sophisticated replenishment system, and the hotline system can stand up to intense pressure. It is in these circumstances that they would be able to do so. And this is a merely commercial act. The government should not be interfering with it. Now, since the health of local babies is at stake, the government finds it necessary to liaise with the suppliers to make sure that they seize the initiative and, in a responsible manner, they improve the supply chain.
Next one. Yes, I want to follow up. I still have some time left. When the government discussed with the suppliers, what about the progress of the supply chain? Chairman, as I said, the hotline system, the frequency of replenishment of stocks, these are the topics that we have started discussion on with the suppliers. Have the suppliers made any undertaking? Yes, any undertaking from the suppliers? Chairman, we don't have any specific undertaking from them yet. Any follow-up? I meant undertaking by the supplier. She has already answered that. The suppliers have not made any undertaking. Mrs. Lai, once again, please. The suppliers, we are still discussing with them. We have to get specific or concrete evidence on improvements. Now, we haven't reached the stage where the suppliers will have given us any undertaking. We have just started our work. Next one, Mr. Low Wai-kwok. And on the 24-hour restriction, I don't think the Permanent Secretary has given us a satisfactory reply and why our suggestion is not feasible. Now, your answer is that many people are leaving Hong Kong more than once within 24 hours, and these people are now breaching the existing amendment regulations. Now, the person can only make use of the first departure in the next 24 hours, and you said that it will bring more convenience to the parallel day traders. Now, our aim is that if the parallel trader does want to engage in parallel trading, he can only do it once every day. Now, having this 24-hour restriction is going to bring inconvenience to people who may forget when he left Hong Kong the last time. And I don't think our suggestion will have any effect on your efforts in clamping down on parallel trading activities. Members are worried that the way you drafted it is too wide. The scope is too wide. And because it says any other relevant circumstances, we've tried very hard to try to narrow down the definition. Now you are relaxing it in this way. Can we narrow down the definition further again? We've been going rounds and rounds of discussions to try to narrow down, and the way you are doing it is throwing all our efforts down the drain. Now, for the 24-hour restriction, it means that people leave in a 24-hour interval. I understand what you say, but I want you to tell me why our suggestion is not feasible. Chairman, I think it is a matter of degree. As I said, if one forgets when he departed from Hong Kong last time, he will forget, irrespective of whatever circumstances he is in. Now, if the person is allowed to bring 2 cans of powdered formula within 24 hours, that would bring inconvenience to the members of the public. I think it's a matter of striking a balance. Any other relevant circumstances? I would defer to Mr. Mo. Any other relevant circumstances? I can only reiterate that those refer to circumstances other than those bound by product descriptions and users' instructions. Say if the label is damaged, and so on and so forth. Without this phrase, the law enforcement bodies will not have the flexibility to enforce the legislation to achieve the desired policy objective. So we have only this choice of adding in any other relevant circumstances. Actually, the example that I cited is case number 9. The Protection of Endangered Species of Animals and Plants Ordinance is very comparable to our present case. That appears from an accompanying document, packaging, mark, or label, or from other circumstances to be or to contain a specimen. It says here that actually the packaging or the label may not serve of good reference for the law enforcement officer. So we need that phrase, other circumstances, there. So actually, in legislative provisions, it is impossible for us to give an exhaustive list of the circumstances. So that's why we have to have these type of phrases to provide for those circumstances. Now, if we interpret the law or that phrase not in compliance with the original intention of the legislation, then that will be open to challenge in the court. Yes, next round, Mr. Vincent Fang. Chairman, I want to ask about the definition of powdered formula. There is a special formula for milk powder for babies under 1 year old. Now, my question is, for babies aged 2 to 3, 12 months to 36 months, are there ingredients different, in the formula from adult formula? Mrs. Lai, Chairman, about the ingredients, I'll defer to the Center for Food Safety to talk about that. Now, for our regulation, we don't focus on the ingredients per se, but rather on the marketing strategies and whether it is claimed that it is suitable for consumption by people under 36 months. Mr. Philip Chan, Dr. Ellen Chen. Now, for powdered formula, in Codex, there are specified ingredients for baby formula. Now, if a product can be consumed by babies from 6 months to 36 months, there are also specifications on the ingredients. The two formula, actually, or the ingredients are different. Why I raised that question? Because it is always the case that powdered formula for babies under 12 months, it will specifically say so, but for milk powder, which can be consumed by young children from 2 to 3 years old, they can also be consumed by the adults. That's as far as I know. Now, if that is the case, that will fall under the ambit of the restriction order. I remember last time, the administration told us that there are around 6 to 7 types of milk powder in the market, which will be regulated under the amendment regulation. In the past, they would not be regulated. Now, I have received many questions and examples from the industry. Now, if the chairman allows, perhaps these 3 pages of paper, can that be photocopied for reference by the administration? There are a number of milk powder here which contain calcium for consumption by adults, and actually a large number of them will be covered under the restriction order. So I'm very concerned about this. I am very concerned about the definition of powdered formula. Now, if the original intention is to focus or target for powdered formula for young people aged 0 to 12 months, then confusion has already surfaced for powdered formula for young children 2 to 3 years old. So can we make a distinction between these 2 age groups so that we can avoid confusion? Last time we talked about food in a paste form, and that created confusion, and that was removed, that confusion. And then this time we are faced with this problem of mixing the powdered formula for babies under 12 months old and babies above 12 months old. Can we make a distinction between these 2 age brackets? Yes, Mr. Chen? No, sorry, Mike, not coming through. Yes. When we consider the issue, I know that Mr. Fang is concerned about powdered formula which can be consumed by adults as well as babies or young children under 36 months old. Now, a simple solution would be that if in the definition we can just say that the powdered formula is only for consumption by babies from 0 to 36 months. But then if that approach was adopted, then a loophole would surface in the definition. Say if the supplier changes the target groups to 0 to 37 months, then he will be able to circumvent the regulation. Now, in reality, in the market, we have collected samples of milk powder, and actually, for many products, they would say that that is consumed, that can be consumed by babies from 0 or upwards, 6 months or upwards, or 7 months or upwards, and so on and so forth. There are many different wordings like those. And Mr. Vincent Fang said whether distinction can be made between, say, 0 to 12 months and then 13 months to 36 months. But the reality doesn't work that way. So in order to prevent any loopholes, and then we have to take care of the needs of the babies we want to take care of. So we can't adopt the approach of saying that the powdered formula is can be consumed by babies from 0 to 36 months. And also we noticed that some market suppliers are going to change their labeling to say that their product is suitable for people 36 months or above. And if that is the case, they can be get out of the scope of a regulation. Now, Mr. Yan has not talked about the situation in New Zealand. The definition under New Zealand is exactly what Mr. Vincent Fang advocated. An infant formula is represented as a breast milk substitute, which satisfies the nutritional requirements of infants aged up to 36 months. And then they draw a line then. And then another definition is an infant product is represented as a breast milk substitute or infant formula, which constitutes a nourished formula to satisfy nutritional requirement for babies. So a distinction is made between babies aged 4 to 6 months and then 6 months upward, which may be feeding on complementary food. For baby formula, then they would define it as breast milk substitute. And for baby 6 months old or above, they have another definition. Is precisely what Mr. Vincent Fang advocated. They did not use sketchy definitions like any other relevant circumstances. So if that is how New Zealand does it, why can't we use clearer definitions to more detailed definitions and use the present approach advocated by the administration? Has the administration looked at what New Zealand has done?
Well, before you answer Mr. Kwok, let me put it to you, Mr. Kwok. When did it happen, what you mentioned? Chairman, I think it was September last year. They put forward this proposal back then. Yes, indeed. Mrs. Lai, we keep emphasizing that in this definition, we're not adopting any scientific approach, because otherwise we need to have every case being tested by the government laboratory before enforcement can be exercised. We have to have regard to the situation. Each day there is so much flow of people across the boundary. We have the individual visit scheme. We have the frequency of high frequency of people traveling back and forth, and we should have a definition which is not scientific based. We have to have regard to the products, and that would make it make the law enforcement smoother, and the people concerned would get the better understanding of whether they are caught by the regulation. Mr. Kwok, Chairman, I think I've made my point. Chairman, I think Mr. Gilbert Mo has a point to make. Chairman, Mr. Kwok mentioned the legislation in New Zealand and the way it is drafted. By comparison here, they use the phrase represented as. They don't really provide for any yardstick. They merely use the phrase represented as breast milk substitute and so on. In Hong Kong, if this is applied to a local situation, it would be different. I don't know how or what the labeling, what the packaging is in New Zealand, but if we replicate this in Hong Kong, then the customs and excise officers will have to ascertain whether this product is represented as a substitute for breast milk. I'm sure it would present far greater difficulties than the definition that we have here. Ms. Ann Chung, first time. Chairman, thank you. We meant to have our discussion for a couple of meetings in March, and now we are in April, and we still are no nearer to a solution. Now, we are well aware that this is a measure in the absence of any better alternatives. Now, we have to make sure that babies in Hong Kong are well supplied with powdered formula. Now, this matter all started in 2010. 3 years on, we haven't seen an improvement to the situation. If anything, the situation has worsened, and hence this restriction order. I think that this is in keeping with the overall interest of Hong Kong. the administration has to safeguard the interests of local citizens. If you can't even safeguard the interests of babies in terms of powdered formula, what else can you do? Now, we can pick the definition to pieces. We can find fault or nitpick with the definition, and we may not be able to come to any conclusion till the end of the year. Now, will there be a review of the restriction order? Dr. Ko said last time that this would be brought under review within a year, or in fact this would be reviewed from time to time. I would urge members to give their support to this restriction order as soon as possible. Right? That's Dr. N. Zhang's view. Dr. Lo Wai Kwok for the third time. Chairman, if we're not concerned about this, we don't have to spend so much time on it. I think the more we discuss, the more we're able to plug all the loopholes. Otherwise, we wouldn't have seen this this amendment. I don't think our efforts have gone down the drains. I don't think the administration has convinced me that this is a better version than the previous version. The previously there was the phrase appears to be. Can we narrow down the definition more? Now, for the relevant circumstances, I think we can confine the relevant circumstances to the product descriptions. I think we have to make sure that the products are intended or claimed to be for persons under 36 months. If in the legal definition you can narrow down the scope to tie in with the legislative intent, then our concerns would be assuaged. And this is the point that I'm particularly concerned in the definition. I'm wondering whether we can do so. Technically, we have so many barristers here, I'm sure that we will never run out of ideas. Mr. Mo? Chairman, it depends on the policy intent. Now, if you say that any other circumstances are related to the product descriptions, then we'll have to find out whether realistically there are circumstances that have got nothing to do with product descriptions and users' instructions, and in individual circumstances the court or the law enforcement will need to have regard to determine culpability. Let's say a laboratory test result to determine whether the product is for children under the age of 36 months. I think I have to leave it to the medical practitioners to tell us whether this is feasible. Now, let's say there are powdered formula that doesn't carry any labeling, and after the laboratory test it is determined that it is meant for babies between 0 and 12 months. Now, these are not product descriptions and user instructions. And in the course of judging the case, the court or the law enforcement agencies would have to determine whether the product is caught by the regulations. So if we link any other relevant circumstances to product descriptions, drafting-wise it doesn't present any problem, but we have to make sure that it is in line with the policy intent. Dr. Lo? Well, I think you've got a very good analysis there, but from the permanent secretary or the deputy secretary, I get the feeling that you are mostly concerned about product descriptions, and this is the basis on which you like to enforce the law. You're not trying to expand the scope indefinitely. So we have to be clear about the objective. If we have a clear objective, then I'm glad to hear from the draftsman that technically this can be drafted. So I'm wondering whether we can narrow down the scope the way I suggested a moment ago, and that would make it feasible to enforce the law without compromising the policy intent, and that would also relieve members' concerns. Mrs. Lai. Right, the chances of using this phrase under any other relevant circumstances is rather limited, because mostly we will look at the product descriptions and users' instructions on the tin. It is in exceptional circumstances. In absence of any product descriptions or users' instructions or any ambiguous situation that we would have to resort to this phrase. I think members have their attention focused on this phrase. Now, for effective enforcement, we do need to have a piece of legislation which is sufficiently broad in scope to cover various situations. If you narrow it down, then we will only be able to cater for that restricted range of situations. Any deviation from that, we're not able to cope. Now, parallel trading can be ever-evolving. It can be very creative, and we may end up with a piece of legislation that can be effectively outfoxed by the parallel traders. Is this something that we would like to see happen? We've got 15 minutes to go before we have to deal with the motion moved by Mr. Dennis Kwok. Mr. Leung. Well, Chairman, I heard from Mrs. Lai, and I feel obligated to say something here. She seems to be saying that between a scientifically based definition and a definition based on product descriptions, she has to exercise some choice. Now, this definition is based on product descriptions instead of based on a scientific approach. Now, for any other relevant circumstances, if the powder formula has to be referred to the laboratory for testing, so be it. As a legislator myself, I think we have to have regard to those who are adversely affected by the regulation. Now, you may try to make it convenient for law enforcement. You may be worried about being outsmarted by the traders. But here there may be a lot of imponderables that will happen. Now, your choice is to not use the scientific approach, and you have exercised the choice, and you have to bear the consequences. Mrs. Lai, I defer to my colleague, Mr. Philip Chen. 2 points, if I may, Chairman. First of all, I keep emphasizing that in the market out there, normally the products would carry the product description and the user's instructions. The suppliers would specify the age bracket that they aim at, and they're intended for and claim to be for consumption by this particular group of people. So when you look at the product descriptions and instructions, it would be very clear, it would be sufficiently clear. I'm sure that would be clear to the members of the public. And I'm sure Dr. Low and Mr. Leung are also concerned that some people may be innocently caught by the regulations. But as I said, when you purchase the powdered formula in the market, now if you go out and do a poll on the street, the purchasers would understand the kind of products that they're buying. They're very clear about it.
We add this phrase not to extend our scope very widely, but we know that for sure that parallel trading activities are evolving, and if we have added that phrase, we still have to prove that the product is intended for or claimed to be for consumption by young children. We're not extending the scope indefinitely. We just want to have a framework which will not be imposing unnecessary hurdles if we enforce the law. Now, what is more important is that whether members of the public know what is powdered formula. And I think a reasonable person would know what is powdered formula and what he or she is buying. Well, just one point to follow up. According to the permanent secretary, so how do you prove any other relevant circumstances? You don't have product descriptions, uses instructions. You can only send it to the government lab for tests. So there are no other ways of doing it to prove what the description following that phrase. So if that is the case, why don't you put it categorically that the product through scientific tests is proven to be intended for or claimed to be consumption by young children? Can we just not state that very clearly? Well, thank you, Mr. Leung. I have nothing to add, Chairman. Mr. Leung, if you think that the wordings are not good enough, you can propose amendments. Mr. Vincent Fang, I want to follow up on the list of adult formula in the 3 pages that I gave you. Our total of 28 milk powders there. His question is that are these 28 types of milk powder under the restriction order, yes or no? Administration, Customs and Excise, can you give an instant reply? I have doubts on that. Perhaps you can go back and take a look. Perhaps later on you can give us a written reply. Whether these 28 types of milk powder come under the ambit of the regulation. Is that right, Mr. Fang? Now, if that sort of definition is adopted, apart from the types of products listed in the 3 pages, will the administration conduct a survey comprehensively on all kinds of milk powder apart from the 28 products listed in the papers? All right. On our table. Yes, Mr. Zhang. I mentioned last time, under the new definition, it is not being put there as a sort of amendment to existing regulations. Last time I mentioned, would the definition have any retrospective effect, the effective date? I asked that last time. As I said last time, we would be based on the chapter 1, tab 1, section 34, and then we would ask the secretary to move a motion, and we plan to take that to the electrical meeting on the 17th of April. We have to take a look at the agenda items that day. We know that we've got a list of items already. We may have to use the meeting on the 18th of April. And then the legislation will take effect on the day when it is gazetted. Yes, tabled before us is a motion moved by Mr. Dennis Kwok. I think the wordings are self-explanatory. I'm not going to waste members' time. So you want to move that motion, right? Now, according to the set procedures, we have to vote. Those who are in support, please raise your hand. All right. Those who object, please raise your hand. Abstentions, please raise your hand. 6 agree, support. 6 object, and 1 abstention. So it has not been passed by a majority. Because there is 1 abstention, a simple majority has not been reached. So the proposed motion is voted down. Now, after this meeting, if members have any amendments, they have to forward or raise it by 24. Tomorrow, in other words, the midnight, the day after tomorrow. To do that, you have to do that before that time. All right, the 10th of April, that is tomorrow. And on the 17th of April, that will be tabled or put forward to the full council sitting. If we want the administration to supplement any materials, we can do it in a written form. And then the written reply from the administration, we will circulate that to everyone before the 17th of April for your reference. Mr. Vincent Fang, what is it that you want to say? For the 3 pages of paper that I submitted, would there be a reply before the 17th of April? Yes, I think that can be done. So I will go after them. 2. AOB? No AOB? I'll declare the meeting adjourned. Thank you very much.